Okay, awesome. I'm frequently asked, what is the number one cause of home inspection claims? And the interesting thing about it is the number one cause of home inspection claims, and by number one, I mean 100% of all claims originate from a bad result. Something goes wrong in a house that you've inspected 3, 4, 5 months later. My personal record is 12 years later. And it typically starts like this. You do an inspection for someone in August, and the guy has a heat pump. And you tell him, the heat pump is operating. You're only able to test it for its cooling feature. You aren't able to test it for its heating function. So you tell your client in the home inspection report, listen, this thing worked. We had good change of temperature, but these devices are very temperamental, and it's very important to have them serviced. And you should have it serviced shortly after you take possession of the home. And by the way, you should also ask the seller whether he's ever had any problem with it. So your client moves into the home in October of that year. And 6 weeks later, in December, the entire eastern seaboard has an epic snowstorm from New Orleans all the way up to Nova Scotia, is blanketed with 35 inches of snow. And that is the exact time that your client's heat pump decided to give up the ghost. So and this particular client also had a newborn. So he packs his family up, heads off to the in-laws until the municipality can remove the snow from the highways, and he can deal with this malfunctioning heat pump. So when the HVAC contractor comes out, he says to the home inspector, your client, that the heat pump is shot. You have to get a new heat pump. And by the way, how long have you lived here? And your client says, well, I moved in October. And next thing he says is, October, did you happen to have a home inspection? And the client says, well, it's a $1.5 million condo. Of course I had a home inspection. Then the HVAC guy says to your client, well, I don't know how the home inspector missed this. So that's how the typical claim starts. Some third party tells your client that he needs to blame the home inspector. In this particular instance, the guy tried to blame the home inspector for it, and I basically wrote to him and told him that he had been instructed to have the device serviced, and also to inquire of the homeowner whether they'd ever had any problems with it. So that case went away actually pretty easily. Now I have handled over 4,000 claims in the last 20 years, and claims are divided into two separate categories: meritorious claims and unmeritorious claims. Now, meritorious claims account for less than 1% of all claims against home inspectors. Why is that? Well, because home inspectors are pretty good at what they do. In those 4,000 claims, only 7 of them have had merit. And I didn't have to tell the home inspector that it had merit. He told me. He said, Joe, I think I actually did miss this. Well, there's not much I can do about a meritorious claim. So that claim went on to the insurance company. But unmeritorious claims fall into 6 separate categories. The first category is it's an off-site issue. Permits weren't pulled. Or it is something that is outside the standards of practice. It's it was concealed, or it was, wasn't something we're looking for. Mold, termites. We're not looking for that in a standard home inspection. Thirdly, it's something that was concealed by carpeting, by behind drywall, underneath carpeting, behind sofas, behind furniture, and so on. Or it's something that was disclaimed in the report. The inspector could not get into the crawl space, so all bets were off with the crawl space and anything that could result from problems in there. The fifth type of category is something that was discovered, and you would be amazed at how frequently this is the issue. You get a call from a client, you go out, and he's got a problem with the roof, and you go out and you look at the problem, and you cannot believe that you missed this. And then you look at your inspection report, and it turns out, gosh, you didn't miss it. There it is, right in the roofing section. A notation of a active stain or a recent stain, and with a notation to inquire of the seller whether or not he's ever had any issues with this since it was repaired. And finally, the last group is something that was working at the time of the inspection, but now 5, 6, 7 months later, it's not working. As I said in the introduction, my actual record for that is 12 years. Someone came back 12 years after the inspection for a roof leak. Now, what can you do about this? Well, fortunately, it's possible to prevent some of these things. These are the issues. These are the steps you need to take to protect yourself from these ridiculous claims. First thing you need to do is align expectations. Most people that have a home inspection, especially first-time homeowners, is they have no idea what a home inspection is. And to the extent that they do have an idea, it's generally one that is crazy. They think you're going to find not only everything that is currently wrong with this house, but everything that has ever been wrong with it. And I think some of them think you're going to find things that are going to go bad in the future. Second thing you need to do is strengthen your inspection agreement. Now, I read more home inspection agreements than anybody in the world. And I would say that about 30% of them are absolutely unequal to the task of protecting a home inspector. Often of them, many of them are just impossible to read. The print is, the types is very small. There's no margins. There's hardly any white space whatsoever. And oftentimes you'll see things on page 1 that contradict clauses on page 2. You can't really have that and expect your home inspection agreement to protect you. The third thing you need to do is to follow your SOP. That is one of the most important things you can do. If you go onto a chat room, you're going to find home inspectors in there complaining that the SOP doesn't go far enough. The SOP is a minimum. In actual fact, the SOP is a maximum. Don't do more than that. You could possibly get into trouble. A good example of that is I was down in Florida at a conference, and a home inspector I know came up to me, and he told me of a case where he did an inspection on a new community, bunch of new houses, and then there was the estate house that was part of the that was subdivided, and he was inspecting the estate house. And he told the client that he was on public sewer and public water, and it turned out that he wasn't. Now, the SOPs, no SOP requires you to determine or even speak to the issue of whether or not the sewer and the water is private or public. And he said it was public, and it wasn't. So we ended up having to pay, along with both the real estate agent and the real estate broker, for that particular customer to get hooked up to the to the sewer system. The next thing you have to do is perform a professional inspection. And I have to say, most guys do. Most of the ones I've seen anyway. Claims that come in to my office, there's never been an instance where the claim was not properly, where the inspection was not properly performed. The fifth thing you need to do is disclaim appropriately. You know, if you can't get into things, you can't get into the attic, you can't get into the garage, or you can't inspect anything in the garage because it is cluttered, then you have to disclaim that. Finally, you have to establish the killer defense. And I will be spending quite some time on the killer defense as we go along. Well, how do you do these things? Aligning expectations. You just got to let them know that it's a limited, non-invasive visual inspection. Limited, what does that mean? That means we're not inspecting stem to stern. We're not going to be, you know, taking things apart and putting them back together again. There's going to be things we're not going to be looking for. We're not looking for mold. We're not looking for, you know, pest issues. And you really need to let them know that, you know, it's limited, non-invasive. What does that mean? That means we're not taking things apart. And visual. What does visual mean? Visual means that we're only going to be able to report on issues that we can actually see. So if we can't see it, we're not going to be reporting on it. Next thing you need to do is strengthen your pre-inspection agreement. Limitation, here's 4 clauses. There's a lot of different things you need in a home inspection agreement, but these are the ones that I think are critical. Limitation liability clause. Where limitation of liability clauses are enforced, it's the greatest thing ever. And nothing takes the wind out of the sails of an attorney on the other side than being confronted with a inspection agreement that contains a limitation of liability clause. Attorney's fees clause. Attorney's fees clause is how you can get your money back if you defend a case and you win. You know, people bring frivolous cases all the time. And if it costs you money to defend yourself and you end up winning, you have a right under the attorney's fees clause to reasonable attorney's fees. Waiver of the statute of limitations. Statute of limitations in most cases is 2 years for negligence in pretty much every state in the union. What you want to do is have a clause that reduces the statute of limitations to 1 year. Now, when I was originally putting the material for this seminar together, I asked a claims man for a home inspection insurance company, and you know, for some statistics, and he told me that 60% of all claims are made within the first year. 90% are made within 2 years. So merely by limiting your client's ability to bring an action against you to 1 year, you have eliminated 40% of all possible claims. That's a pretty good return on investment. Arbitration clause. Arbitration clause, there's 2 schools of thought on this. Some people don't like them. I love them. And the reason I like them is this: most claims for home inspections are generally within the small claims court area, $10,000, $15,000. And by having an arbitration clause, you're moving this claimant out of the small claims court venue into the arbitration venue. And we'll show, I'll speak later about how that helps you in small claims courses. And you also want to name the American Arbitration Association as your arbitrator. Follow your SOP. I cannot stress this heavily enough. The SOP is your friend. Nobody reads more SOPs than I do. I think I've read virtually every one of them. And if you read your SOP on any kind of a regular basis, you'll soon discover that there are multiple paragraphs that begin this way. The home inspector is not required to : A, B, C, D through Z. There's a lot of things you don't have to do. So it's very important to not do that. So your home inspector, I get calls from inspectors all the time where their insurance company refused to cover them because they had not gotten a signed pre-inspection agreement. They think it's the end of the world. It isn't, because you still have the SOP. And I would urge you to look at your SOP and see all the protections that are in there for you. Perform a professional inspection. I can't give you any help on this. You're going to have to do the inspection yourself. That's the one thing I can't help you with. Disclaim appropriately. Now, whenever I talk about this, someone will raise a question of, can't you have too many disclaimers? And here's the answer: no, you can't. If you ever watch Jeopardy, I don't watch much television, but I do watch that show. They have a lot of commercials on there for pharmaceuticals. And those disclaimers are hilarious. Don't use if you're this. Don't use if you're that. May cause death. May cause death. You have to disclaim. So there's, everywhere you go, you see disclaimers. I was in a hotel recently, and in the shower, there was this disclaimer written on the shower wall. Place curtain inside tub before turning on the shower. You really got to tell people. You got to tell people everything. Establish the killer defense. Now, I want to spend some time on this because this is key. This is the key. This is the number one takeaway from this seminar. Killer defense is contributory negligence. And what's killer about it is almost every attorney I've encountered doesn't know that it's still a valid defense in home inspection cases. Here's the contributory negligence. Contributory negligence is a common law doctrine that states the following. This is the actual jury instruction. The judge will tell the jury, if you find that the defendant contributed in any manner whatsoever to his own injuries, you must return verdict for the defendant. So if the plaintiff is 99% negligent and the defendant is 1% negligent, he loses. He loses under the contributory negligence defense. Now, here's what happened. People were going, there'd be cases where someone was horribly injured. Let's say a child. Child runs out in the middle of the street and gets hit by a car and is horribly injured. It's not killed, it's worse. He's horribly injured. So the jury gets the case and the judge tells them that if they think the kid was 1% negligent, they're not going to give him any money. They can't give him any money according to the jury instruction. So what happened was jurors were going back into the juror deliberation room and contemplating this instruction and saying, that's crazy talk. Give this kid nothing. He's quadriplegic. So what happened was jurors started ignoring. They started to ignore that instruction and would return verdicts for these horribly injured people who had put themselves in danger. But then what happened was every once in a while you'd have a jury that followed the instruction. And so someone that was horribly injured wouldn't get anything. So what happened was lawyers got together and they said, look, it's not fair. It's not fair that some injured plaintiffs are getting a verdict and others aren't. So what they did was they concocted this, what's known as comparative negligence statutes. And what comparative negligence statutes did was they codified what juries were doing anyway. So the typical one states that if the plaintiff contributed to his injuries more than 50%, if he was more than 50% contributorily negligent, he loses. But if he was less than 51%, he gets a verdict, but the damages are reduced by the amount of the negligence, amount of the defendant's negligence. So if the award would have been $1 million and he was 25% contributory negligent, they would only give him $750,000. So that works really well. But here's how it plays in a home inspection context. When these legislatures concocted the comparative negligence defense, the comparative negligence doctrine, they only did it with respect to personal injury or property damage. Well, those are two things that never happen in a home inspection claim. Home inspectors are not in there making roofs leak. The roof just leaks on its own. So the beautiful thing is, if you set this up properly, it's a conclusive defense. And what you need to do, here's how you do it. Let's say you go look at a roof, and the roof's questionable, but it's still, it's still doing its job. And you tell a guy, look, this roof is seen better days. But I couldn't find any leaks, but you need to have this professionally evaluated by a roofer. Or same thing with the electrical system, same thing with the foundation structure, same thing with the exterior and so on, windows, whatever. You looked at them, they seem to be performing as after a fashion, but you really, really need to have them properly evaluated by a specialist. If they don't do that, they lose. They were contributory negligent. And that's where contributory negligence, 1% defeats that. Okay, so that's critical. That's the takeaway from this seminar. Okay, let's see if you actually get into the law. Here's why you never want to begin a lawsuit, because there's multiple parties in these lawsuits. You got a seller's agent, agent's broker, buyer's agent, buyer's agent's broker, the home inspector is incorporated, the inspector's corporation. Okay. Sometimes you'll see fraud allegations. Generally, these are made against the seller. He knew there were certain issues with the house and he failed to disclose them. That's fraud. And the best thing about fraud is this: there's no defense to it. There's no defense to fraud. And the elements of fraud are as follows. You need to have a misrepresentation. The misrepresentation has to be material. It has to be important misrepresentation. And the misrepresentation has to be relied on by the person that receives the misrepresentation, and the misrepresentation needs to cause damages. So you have misrepresentation, materiality, reliance, and damages. If you establish those four elements, you win. There's no defense, you win. Negligence, on the other hand, has multiple defenses. So first, the best defense to negligence is we weren't negligent. In order to establish negligence, you have to establish five things. You have to owe a duty to someone. You have to owe a duty. You have to breach the duty. The breach of the duty has to cause damages. So you have a duty breach, causation, and damages. Now, how does this operate in a home inspection context? Well, you have to owe a duty to the person. Let's say you do a home inspection for somebody, and 6 months later, you get a call from somebody else that says, "Hey, you did an inspection on this house, and the roof is leaking, and I want you to pay for it." And you look at it at the guy's address, and you remember inspecting that house, but you don't remember inspecting it for this guy. So in that case, what happened was the guy you inspected it for, he didn't buy the house because of all the things you found wrong with it. The second guy comes along, the real estate agent hands him your inspection agreement, your inspection report. He buys the house. Well, you don't owe a duty to that guy. You never did anything for him. You do not owe him a duty. So boom, you win because there was no duty. Or let's assume you did something for a client, and 6 months later he has a problem, and it's this house that had the leak that you found, and you go and you look at it, and it turns out what he's complaining about you found. It's right there in your report. So in that case, you don't have any breach. There's no breach. Or oftentimes you have a claim where there was a duty, someone breached the duty, but it wasn't the cause of the damages. Someone they do an inspection for someone, electrical system. There's a problem with the electrical system that, if uncorrected, might cause a fire, and then the house catches fire. But it didn't catch fire from the faulty electrical system. It caught fire because it got struck by lightning. So in that case, you have no causation. So again, no responsibility for that because of lack of causation. And then there's the final example is you do an inspection for somebody. Turns out you missed something, and your damages are caused as a result of your missing that. But the damages, the guy doesn't have any damages because the roof is 30 years old, 35 years old. You're not getting a new roof. You're getting a new roof depreciated by 30 years. Nothing, no damages. You don't have any damages. And it's when you go to a grocery store and you buy something for $17 and you hand the kid $22 and he hands you the $2 back and says, no, it's only $17. He doesn't realize that, you want a $5 bill back, you don't want 3 singles. And so whenever I do that, I'm always wondering whether they're still teaching math in school. Well, when I get these ridiculous claims in from attorneys, claimants' attorneys, I start to wonder whether they're still teaching the law of damages in law school, because these claims are not worth anything near what these claimants think they are. And the roof is a good example. You have a guy has a leak in his roof. He thinks he's getting a new roof just because he has a leak. No, you're getting the roof, you're getting the leak repaired if we were responsible. If we're responsible, we'll repair the roof, but we're not getting a new roof. You're getting it repaired. There's nothing wrong with the rest of the roof. Okay, let's talk about small claims court. If you've never been in small claims court, it is just like night court. If you remember that, it's just like Judge Judy. But you can win in small claims court. In fact, I have a tutorial that teaches you how to win in small claims court. And my clients are batting 1,000 in small claims court issues. And one of the reasons they're batting 1,000 is because of the arbitration clause. You come into court and you say, my clients will say to a judge, Your Honor, I think I can short circuit this proceeding here today, because you see, the plaintiff and I have an agreement. And one of the terms of that agreement is that any dispute between us must be brought in arbitration. And the judge will say to you, do you have a copy of the agreement? Of course you do. And you have the arbitration clause highlighted. And you give a copy to your opponent as well. And the judge reads the clause and then says to the plaintiff, is this your signature on this contract? And the guy will say, yeah, that's my signature. I said, well, you're in the wrong venue. This court has no jurisdiction over the subject matter of this dispute. You have to go to arbitration. And I'm telling you, it works like a charm. It absolutely works like a charm. Now, if you didn't have the arbitration clause, of course, you'd have to try the case. And again, you're the pro. Basically, what you do is you listen. You don't interrupt like they do in Judge Judy. You listen to the facts, and you make your points against him. If he starts lying, which, believe it or not, people do lie in court, and then you just, hey, we don't have to find things that we can't see, and generally it works out in your favor as well. So that's how you win in small claims court. Talk a little bit now about insurance. Many home inspectors hate the idea of having errors and omissions insurance. And what I frequent excuse I hear is it puts a target on your back. So not having, and you know what, that's probably some truth in that. But here's the problem. Not having insurance does not remove the target from your back. You still have the target on your back. And the whole thing about insurance is lawyers, most lawyers that I know, and I do plaintiff's work as well, they are not inhibited by the fact that a claimant, that a defendant does not have insurance. In fact, they're delighted by that generally, because it's an easier case to win. The plaintiff's going to have to spend money on an attorney, and eventually, those costs are going to get to him, and he's going to be in a settling mood. And that's really what you want as a plaintiff's attorney. You want to settle these cases, because trying them, first of all, it's a lot of work, and you seldom get back what you put into it. But no, that's ridiculous. It doesn't put a target on your back, and it doesn't remove it if you don't have it. And by the way, there's numerous issues that are not covered by insurance that people sue on all the time. Reputation, defamation, those kinds of things. Speaking of defamation, what is the likelihood of having a bad review on social media? Well, here's the thing. There's so many places where you can be where they can make these problems yours. Google, Yelp, Home Advisor, Angie's List, and these reviewers are very vindictive. Oftentimes are vindictive, but you can do something about it, and that's the important thing. I want to talk a second about the Streisand effect, because people call me, Joe, I have 200 5-star reviews, and this guy come on and he's just laying into me. Well, they want to go back and they want to they want to go on Google, go on Angie's List and these places, and they want to set their record straight. That's generally a bad idea because of a thing known as the Streisand effect. And the Streisand effect is this. Barbara Streisand has a very private home right on the Pacific Ocean. And what happened was the NOAA commissioned a photographer to fly up the coast of California and take photographs of the shoreline, in order to have a baseline for, erosion. So Streisand heard about this and objected. She objected to this photographer putting the photograph of her estate on, and there it is, on his website, and he refused to take it down, right? So she goes out and files suit against him to get him to take it down, and he still won't do it. But TMZ and other outfits like that, they go into courthouses all the time, every day. They go in every day, see any new lawsuits been filed by celebrities. Well, Barbara Streisand is a pretty well-known celebrity, so they grabbed this, put it on TMZ, and the next thing you know, this photograph, which prior to her filing suit had been downloaded, I think it was something like 75 times. Within 4 weeks after she filed suit and TMZ got a hold of it, it was downloaded 180,000 times. 180,000 times. So that's known as the Streisand effect. Now, when you respond to these negative reviews on the website that's carrying it, that goes right to the top. It goes right to the top. And if you're a good inspector and you've got 500 5-star reviews, you're going to bury that in your next 10 inspections. But if you don't get it buried and you really want to get it taken off, there is the powerful tool of defamation lawsuits. Now, when inspectors call me about someone who's giving them a really bad, really negative review, a very negative, unjust review, there actually is a remedy for that, and that remedy is a defamation lawsuit. And what makes the defamation lawsuit so powerful, in fact, that no less an attorney than James Beasley, late James Beasley, after whom my law school is named, he said it's the best tort that there is. There's no better tort than defamation. And here's why. You do not have to prove damages. In other words, you don't have to go in and say, because of this review, I lost $4,000 in business, 10,000, whatever. You don't have to do that. You don't have to, they don't even ask you for damages. And juries throughout the length and breadth of this country have absolutely no problem whatsoever at returning massive verdicts against defamation defendants. Here's one in, where is that? Michigan, looks like. Is that Michigan? No, that's Minnesota. Okay. $1 million. $1 million for defamation, not excessive. Here's the next one. This is in Arizona. $2 million. $2 million defamation verdict is not excessive. $2 million. Would that brighten your day if you got that? Here's one, Ohio. $50,000 compensatory damages, $225,000 punitive damages, not excessive. In other words, this case went up to a higher court on the grounds that the award was excessive. And this court is saying, no, that's not excessive. Here's Pennsylvania, my home state. $196,000 damages in a false light case, not excessive. False light means the thing may have been true. The defamation may have been true, but it put the guy in a false light. They altered it, so they put him in a false light. Here we go. Illinois, 8 million. 8 million damages, not excessive, which means it got affirmed. 8 million got affirmed. 2 million, North Carolina. Here's the next one. South Carolina, 50,000 in compensatory, 225 in punitive. Florida, 18 million in Florida, $18 million, not excessive. Oh, and what's good about that one is it was true. What the guy said was true, but again, it was a false light. It was a false light case. I'm lost myself here, so I need to get some technical help here. One of my colleagues is trying to help me. Oh, here we go. See it over here. Wow, it's almost 4 o'clock, so I guess we can open up for questions. Are there questions?
There are. We have several that have come in. Fantastic presentation so far. Let me run through some of these questions that we have. One is, Joe, can you touch on how important it is to mention in your report inaccessible areas? Do you recommend that they are in the report, that the inaccessible areas should be inspected prior to closing?
I do recommend that. And if it's inaccessible, you absolutely have to put that in there. And I would highlight it also because I get a lot of these kind of cases. Crawl spaces, especially. Crawl spaces, I think it's got to be 24 inches as a minimum. Otherwise, you're not required to go in. And sometimes you go into these crawl spaces and they're accessible, but it's chock-a-block with water or clutter. You got to take a picture of these cluttered places because they're key. When I point that out to an opposing attorney, he's like, why did this guy come in with this case? Yeah, so if you're not able to get into the attic or unable to really inspect it because it's chock full of items, you have to demonstrate that. You have to disclaim it, and then you have to demonstrate that why. Look at all this. This is like the source of the river eBay. Some of these places.
Now, given obviously nuance in law is important, I thought the phrase used in the question was interesting. Should you also, therefore, in the report, make a recommendation that they should get it inspected before close, or should you just draw the line at?
I would recommend that because, a crawl space, not being able to get a crawl space could open up an awful lot of horror. There might not be a vapor barrier. There may be floor joists that are, compromised fatally. yeah, I think you should check with the have this looked at by a professional before closing. Yeah, absolutely, because that's absolutely going to come back to haunt you, you know. But if you do all that, you know, and I mean, I've been very successful at getting rid of these cases where the home inspector has adequately reported and adequately advised the person to go forward.
Great. Now, obviously, law is always based on where you practice law, but we do have a question here from one of our inspectors in Canada, if you're happy to answer it. They do say, do you have any advice for inspectors in Canada where provinces regulate and require licensing plus submission of our agreements to the governments for approval?
Wow. Well, that is, I really don't. I think though that if you follow the basic recommendations in this seminar, I think you're going to be all right, even with that much government control. I mean, what is the government doing? They're outlawing certain, you know, clauses in your agreement. That's sort of I'm at a loss there. I just don't know what to tell them there.
No problem at all. I appreciate you giving that a go outside of your country of licensing. Couple here, at what point would you suggest to defer to professional legal help when you have received a client complaint?
Well, here's the thing. Once you receive a complaint, the clock is running on reporting to the insurance company. And there's many cases I've had where someone handles the claim themselves, you know, oftentimes successfully. But there are times when I just had this case actually where the person handled it themselves and it seemed to have gone away. And then the guy came back with some more nonsense, and then he contacted me, and I wrote a response, and the guy went away for another year, right? Because 2-year statute of limitations. So the guy goes by for another year, and then recently, about a month ago, this fellow got served with a lawsuit, and I told him, I said, well, you know, did you notify your insurance company like I instructed you to? Because I always after I send a response, I always advise my client to notify the insurance company, because once you notify the insurance company, they're on that claim. They're stuck with that. Even if you go out of business, even if you change insurance companies, once you report it to them, they're stuck with that claim. So if he had reported it to this company back in, you know, when he first handled it, if he had said, hey, I had this come in and I think I handled it, but I just want to put you on notice. I think the guy's going away, but I just want to put you on notice. That's the way to do it with these insurance companies, because they love the first thing an insurance company does when a claim comes in is ascertain whether they're going to cover this claim.
Right. And
if a failure to report, you fail to report, that's like knocking over, you know, milk bottles. You know, I mean, it's easy for them to, you know, to get rid of that claim.
And the reporting time frame for the insurance company may very well be different to the statute of limitations for the inspector to have a lawsuit brought against them. Correct? It
could be, yes. Most of the time, I can't speak for every insurance company, but most of the ones I've seen has been 60 days. 60 days you have to report a claim. And you know what they do, here's what they do. My experience has been this. If I write a response, generally people consult me right away. I'll write their response and then tell them to send the response to the insurance company. And you know, hey, here's a claim that came in, and my attorney's response to it. I don't think we'll hear from this person again, but in case we do, I just wanted to let you know, right? So if you do that, what the insurance company will then do is they will pen that. They'll pen it for 6 weeks, 45 days. And if neither I nor my client has heard from that claimant within that 45 days, they close the file. Subject to reopening it again if this guy ever resurfaces. And that's really what you want to do. That's the way to tighten it up. Tighten up that so you're not going to be in a position where they're not going to cover you.
Now, there is a question here of, would you recommend inspectors then to always have E&O insurance?
I would.
Yeah.
Would I recommend them have life insurance? Would I recommend they have disability insurance, health insurance, auto insurance? Yes.
Yeah. Okay.
Insurance is for the unexpected.
Right.
I mean, I've had inspectors do 10,000 inspections and call me up and say, Joe, I've done 10,000 inspections. I have never, ever had anybody, I've never had a claim. Done 10,000 inspections. Is the claim valid? In all likelihood, no. Why? Because this guy knows how to inspect. It's really quite remarkable. You could be the greatest inspector in the world, doesn't matter. Somebody has a bad result, his brother-in-law tells him he should go after the home inspector. And that's the typical claim.
The joys of the person claiming their or believing their friend or somebody on Facebook and taking action.
Always.
Yeah.
Right.
It is a valid point, because there is so much about business that we do where any of us as individuals might feel we are great at what we do, but it's the unpredictability of everybody else. Right.
That's what insurance is for. If there were some other way, if someone could come up with a way to not have insurance, he would win a Nobel Prize.
Sure.
There's just no avoiding it. It's the best product ever for what it does.
That's right. Now, on the same sort of vein, is it best for an inspector to have some sort of corporation, LLC, etc., sitting between them and their customers?
Well, here's the thing about that. If the inspector is doing the inspection, it's not going to matter whether he has an LLC or a corporation or whatever. LLCs would protect someone who IEB is counseling, who they're no longer inspecting. They have 7, 8 different inspectors, and they're not inspecting anymore. So the corporation would protect them in that instance. But if you're doing the inspection, you're stuck. It's like you have a corporation, and your company car, your truck is owned by the corporation. You run over a kid, your corporation is not going to protect you there. So right. And there's reasons to have an LLC, that tax reasons or whatever. I'm not a tax lawyer, but it doesn't do anything for you as far as liability is concerned.
I'm glad that question came up, because I think there's a lot of misconception about it in the industry.
Oh, there is, yeah.
Now, there's a couple of questions here where the team and I, some of the team and I signed off from your presentation for 10 minutes to prep for the next one. And so I don't have the context of these. So I'll ask them. And then if you have the context, then great. So let's see. They say, hang on, they might have disappeared now. Somebody made comment to something about the Babs scenario.
Oh yeah, the Streisand effect.
Yeah, and I don't actually see those questions here now. So somebody called Bill asked those. If you want to post that question back in the chat, I'm happy to ask Joe about it. Okay, let's move on then. So Jason asks, do you have an opinion on the pre-claims assistance programs that insurance companies are offering as part of their programs or policies?
Well, I get a lot of questions on this, and what I tell the people is that those people are not representing them. They're representing the insurance company. And there's a lot of people have found out to their heartache that that is the case. I think they're probably okay as far as they go, but they're not representing you. They're not representing you, and if they're telling you that they are, that's really not true.
Right.
They're representing you to the extent that your interest aligned with the insurance company's interest. To the extent those interests diverge, you're out the cold.
Right. Quite true. Okay, the Babs ones have popped back up. So a couple, again, I don't have the context for these. The Babs picture showed an illegal drainage pipe down to the beach. She had to pay to have it fixed as per California EPA.
I don't know. I don't know whether she did or not.
Okay, no, fair enough. All right, lots of people leaving comments. Great presentation. Thank you very much for your time. The one last question, have you ever reviewed the Inspector Pro insurance contracts that they provide to us inspectors to use?
No, I have not.
Okay,
great. I'm sure they're okay though,
Right, great. Joe, any final thoughts?
Just, go to my website if you have questions, contact us. It's joeferry.com. I think that's what it is, joeferry.com. Actually, I'm certain that's what it is. And the contact is contact@joeferry.com. And welcome any kind of inquiry whatsoever. Yes, absolutely.